Hey everyone, my name is Rashawn. I'm here with my colleagues Rajveer and Sean Gehani. We are the founders of the American Immigrant Investor Alliance, a nonprofit created by and for EB5 investors. Just a reminder for those of us who are joining, we are a 501c4 organization. Uh, we were registered in DC. Our goal is to represent EB5 investors. We started this organization a few months ago when we realized that the EB5 program lapse was likely, and we understood that given the controversy surrounding EB5 and the issues surrounding them, investors' voices aren't often heard. And that was our reasons for starting this organization.
So, as stated in our newsletter, AIIA's sole focus over the past few weeks has been the Foreign Investor Fairness Protection Act. The goal behind that is there is industry infighting and disagreements going on over the future of the program. What we want is to decouple the fate of existing investors from the future of the EB5 program. The Foreign Investor Fairness Protection Act protects all existing EB5 investors, anyone who has filed an I-526 petition at a time the Regional Center program was in effect. That has been our sole goal over the past few weeks. All of our efforts on all the different fronts have been with the goal of getting FIFPA enacted. So we've had conversations with various members of Congress. So over the past few weeks, we had conversations with Senator Gillibrand's office, who's a Democrat from New York, and Senator Cory Booker's office, who's a Democrat from New Jersey. The calls were very positive. Both the staffers from both the offices, they assured us that they're going to make a few phone calls, they're going to see the political atmosphere, and they're going to get back to us. We do hope that all these people we have talked to, one of them will take up the mantle to sponsor or co-sponsor FIFPA. So that is our goal with all these congressional calls. The other goal with these congressional calls is basically to change the perception of the EB5 program. Whenever you talk to these staffers, most of them don't know about the EB5 program. Others who do know about the EB5 program, they have this perception that the EB5 program is a cash for visa scheme. We really want to change the perception of the program, and I think we are being successful so far.
Yeah, so just to sum up a little bit regarding why FIFPA is so important to us. Now, first of all, I want to make it clear for those of you who don't know what the Foreign Investor Fairness Protection Act is, I highly recommend you go to our website, goaiia.org, go to our blog post. You'll see a copy of this blog here. This was posted about a month ago, where we're basically giving an entire summary of what our agenda is with this bill. You can also see and view the language of FIFPA, so you can see exactly what this bill says. We want to be transparent with those people that we're working with. For those of you who have donated to us, we want to make it clear what our agenda is. What this bill essentially does, and it's a very simple one-page bill. It's a non-controversial bill that does not ask for new green cards. It does not change anything. It simply is more of a fix. What the future of EB5 looks like, how much the investors should invest, where they should invest, the TA rules, that isn't something that's really our concern as existing investors. Our goal is to simply get our immigrant petitions processed. EB5 is an immigration by investment program, meaning you're getting an immigration benefit because of the investment that you have made. Your investment is with your developer, your investment issuer. Your immigrant petition is with the US government. And that is who we're petitioning to allow our process to continue.
I guess I'll just sort of continue on with the progress report. So you did talk about congressional outreach. We are also reaching out to other stakeholders that are relevant within the EB5 space. And this includes a lot of EB5 service providers. These are attorneys, investment issuers, foreign migration agents, to the extent that a lot of them, we're finding are like-minded and care about the fate of existing investors. Something that we've been harping for quite a while now, and it is our firm belief, is that we feel that new investors will automatically come. We feel that the industry will thrive when the existing investors are served a fair deal. And our job here is just to make sure that our voices are heard. We're working with all of the stakeholders. We're not alone in this ecosystem, where this ecosystem consists of many parties which bring lots of things to the table. But obviously what we found missing in the ecosystem was a singular voice that could represent investor interests. So that's really what we're doing. So as part of the ongoing outreach efforts, we did reach out to AIIA, the EB5 committee of AIIA. We actually just had a call with them last week, and we're again socializing the concept of grandfathering, why it's so important from not just from an EB5 perspective, from a broader, but from a broader immigration perspective as well. Grandfathering has, there's a lot of precedents out there, and certainly, creating a precedent of this kind would be, again, I leave it up to the experts, and that these are the type of things that AIIA is going to be deliberating on as to whether, they can get behind this in a way that, aligns with what they stand for. So those deliberations are underway. We're expecting to hear from them this week, and what we're hoping that they'll do for us is essentially put us in front of the AIIA National Committee, who will then actually have the tool and the teeth to make and effect those changes through their resources, including their lobbying resources. So essentially what we're hoping is that we're able to converge our lobbying efforts that we're doing in Congress along with lobbying efforts of other organizations. Once again, I want to say that this is a whole ecosystem, right? We don't stand in isolation of others, and others don't stand in isolation of us. So therefore, our job is to make sure that we're talking with every single stakeholder, and that's an outreach effort that will continue. Moving on from there, this is a brief update. We don't have a lot to share on this just yet, but we'll certainly, again, put out a dedicated blog post, I imagine, once this thing goes through. But we're actually putting a FOIA request with USCIS on certain data points that have been, I guess, missing from the industry for a fair bit. So, given that we have this forum through this organization, and given that this data would be relevant to everybody who's in the really in the ecosystem, we're putting out an information request to get certain data points. And these things, again, we're deliberating exactly how the FOIA request would be drafted. We have some specialists working on that. But the broad context of this is just to sort of glean how the USCIS productivity has been on different form types, including the 526s that have been put on abeyance, and really looking at how the USCIS might be reallocating their focus, because we do know that, just because the program has essentially lapsed and a class of forms have been put in abeyance, that doesn't mean there's not work left in front of them. In fact, we do know that there's a lot of outstanding form sets that they could be working on. So that's the type of information we're trying to glean from that request.
Just a bit on the FOIA request. We are prepared to go to court if necessary, because USCIS usually stalls all FOIA requests. They have a backlog of FOIA requests, they have a backlog of everything. But we are prepared to go to court if necessary to get those data points. And that's a power an organization like AIIA brings to the table. So in media outreach, we have been reaching out to media outlets. We don't always get a favorable response, but we have gotten a favorable response from a few media outlets. And they ask us for quotes, all that stuff. Just to keep you guys updated, we are seriously looking at hiring a PR, a public relations firm, in various EB5 target countries to raise awareness about reauthorization and the organization, all that stuff. Because we do believe that surprisingly, a lot of people in, for example, Vietnam or other countries don't even know that the program has lapsed at this point. And the more awareness we reach, the more noise we make, the more pressure that puts on the industry to get a reauthorization done. And that more support we get for our FIFPA bill to grandfather existing investors.
Now, let's talk a little bit about reauthorization, because I know that's something everyone's worried about. So, as of the last information that we have, we think, and this is the estimate that the rest of the industry is giving as well, that September 30th appears to be when the program may get reauthorized. There may be a short-term extension, or there may be a full-fledged reform bill. Now, none of this is guaranteed. Hopefully, when we're closer towards the end of September, we will have clarity on what the industry factions are doing and if they've reached an agreement or not. In the meantime, we can't stay idle, and which is why we are pushing FIFPA full-fledged ahead. We're looking into hiring a lobby firm to represent us, to represent this bill, and hopefully push this forward to Congress members. So I want to talk a little bit about just our current financial status, because I think it's really important to understand how we started, what we thought we would do, and how our plans have changed so far. And this is something that has evolved over the last few months. And this is something that's been new to all of us. When we first started this organization, we did not realize, first of all, how much pain this immigrant community feels because of this lapse. We knew we had to advocate, and our goal was to raise a certain amount of money, enough runway for a few months, so that we could afford a political consultancy, not a lobby shop at the time, and use that to take our agenda forward. We figured we would have long-term goals. We would work towards them, chipping away at it month by month. As this lapse happened, and as we have seen the industry factions work towards a reform bill, we've realized just how much we need our voices heard. We did not think that we would ever be able to get to that stage, but now we're at a point, because of the tremendous amount of faith that we've seen from folks, and just the encouragement we've received, we believe we can hit this target of raising enough money for a lobby firm, hire one, and push the needs of our investors forward. So with that, I'll hand it over to Sean if you want to add anything to this.
Yeah, so just on the financial side, one thing that we, again, heard from you all, and what we're seriously considering is, you've asked for financial transparency, and we fully realize it's important. We're also a young organization who actually doesn't quite have all of the machinery and the infrastructure required to make that financial transparency possible, but we're making our attempt. So these are some of the 2 expense pools that we've established at this stage. We have a general expense pool, which basically is the expense pool that's needed to sort of run the functioning of the organization with enough runway, enough cash flow for a few months so we can pay our bills, technology expenses, administrative expenses, even the cost of setting up the 501c4, the accounting expenses that come along with that every year, the reporting. And then, of course, we do have legal expenditure as well. So again, surprising to think, but we have started incurring some of that. The costs in drafting the FIFPA bill, for example. We're also part of some legal cases which are EB-5 precedent building, where we would actually, in a measured way and in a very strategic way, incur some legal expenses. And finally, of course, the political consultancy, which really puts us on the map. So those are part of our general expense pool. We have segregated the funds that we're getting from a certain date onwards, from when we actually started pushing the FIFPA agenda and the lobbying targets. As Ishan mentioned, we've sort of shifted the goalpost a little bit. Every single dollar that has come in after that date is now actually going towards the fundraise target for the lobbying. What we have determined, and there's 2 ways to do lobbying. One is, of course, you could do a retainer agreement, which becomes a long-term recurring expense. But we also realize that time is of the essence here. And we do realize that there's some sensitivity around September 30th for all this to happen. So right now we're looking for a 3-month minimum. That's the minimum a lobbying firm would agree for. Ideally, they would prefer a 6-month agreement, but we have convinced some of them to essentially go in with a very surgical approach, given that a lot of the sort of the conversation around EB-5 already seems to be happening. So this is just a matter of representing this singular interest. So that's basically that. The other thing is, we are fully prepared to disclose the actual audited financial results, on a predetermined, most likely at the end of the fiscal year, if possible, and if our means allow us, maybe on a semi-annual basis, so that every single donor gets an idea, at the end of the year, in a confidential, audited, financial summary, to show you how the expenses is. So that's the level of transparency. I guess the message I'm trying to convey is that, us being, who we are, and not being, not having every single skill in the arsenal, we're trying our best at financial transparency. But if any of you come forward and would like certain more information, we're happy to have that conversation. We've just been advised that at this stage, because we don't have our results audited, that we should not be disclosing them. I think that's on the financials, and we'll take questions on that topic as in the town hall.
Okay, so with this, I'm going to step into the lobbying aspect and what we've been working on so far. But before we do that, Rajveer, do you want to explain to folks exactly what is the difference between using a lobbying firm and versus, say, the political consultancy that we've been working with so far?
Yeah, I mean, the general goal of a lobbying firm and a political consultancy is kind of the same. So what a political consultancy does is it helps the organizations such as ourselves build this grassroots effect, this grassroots effort to affect long-term change. That's what a political consultancy does. What a lobbying firm does is, however, it's a more surgical tool. It does a short-term effort to change policy or law. That's the main difference between a lobbying firm and a political consultancy. So something like Crossroads campaigns, they're helping us build up our political message to gain followers and volunteers and supporters and have conversations with these members of Congress and changing the perception of the EB-5 program. Whenever we go to a congressional office, we show them the draft of the FIFPA bill. However, to actually affect that change, to find a sponsor, to find someone who will stick their neck out, we need a lobbying firm, someone who will make a surgical effort to look at the political environment, make all the right calculations, and target members of Congress specifically for FIFPA. So that's the main difference for why we need a lobbying firm right now and why having a political consultancy alone will not get FIFPA enacted in the time frame we need. That's the main difference. Right now, we're in the process of finalizing the lobbying firm we want to work with. So we have had calls with 4 or 5 different lobbying firms of varying sizes based in different parts of the country. And we're trying to finalize the lobbying firm we want to work with, depending on the size, their previous experience with immigration and EB-5 in general. Our goal is to sign a retainer, a 3-month retainer, by the first week of September. September is a goal for us because that's when the Senate comes back into session, and that's when the conversations on reconciliation and omnibus, all of that's are gonna resume. That's gonna happen by the first week of September. So our goal is to have a seat at the table with the lobbyist in time for the reconciliation, the omnibus, or any other must-pass legislation that Congress might take up in the September to October timeframe. So that's our goal right now. Now, FIFPA, it might be, depending on what a lobbyist tells us, it might be introduced as a standalone bill, or the language of FIFPA might be included in a larger reconciliation or reform package.
And just for everyone's benefit, for those, especially those that are joining us new, April is when we got formed. We really began our advocacy activities just before the June 30th lapse. Some of you may recall we had certain webinars just leading up to the lapse or soon after. Long-term authorization, so September. So we're still tracking with that, right? Like as we said, we know that the Senate will be and the Congress will be in session starting in September. So that is still something we're tracking towards, although what has obviously changed. And we're very appreciative of the industry groups. Again, I just want to mention this, like for me personally, that ecosystem concept is really, really key to getting mutual success. What we have been telling industry groups is we can help effect the change in perception that this program badly needs, right? The industry can come in and basically bring in their technical experts and bring in all their vision for what the future of the program should look like, but we're the consumer aspect of this program. We're the consumers of this program, and therefore we make the most direct impact when it comes to changing perception, because perception in media is far from reality. Like a lot of you would associate with the fact that all those media memes out there about this program largely don't apply to you. And that's our job, is to improve perception, build that echo chamber with which the industry groups can do their jobs more effectively. Now, obviously, we have been provided certain, maybe assurances is a strong word, but or maybe not, but assurances about grandfathering. We hope that happens, but again, just being practical, with all of our timelines and all of our, really our fate stuck in this process, we have to have options. So we are prepared to take grandfathering as a singular legislative item. So again, September, we're tracking with that. And then this is where I actually want to go to the next slide. So this is where the future, we have been able to sort of fine tune a little bit. So this is what we're proposing right now. And we're in the process of, this would be a consultative process with not only with amongst ourselves internally, but with you people as well in getting the feedback. In fact, I would like to devote some time in the town hall to see what you guys would like to see out of this process, what you think are the highest priority items, and then also working with the experts in the field, the lobbyists, in terms of what are practical items that can actually be done, right? Because we can have a laundry list of items, but we have to basically match our expectations to what's possible. So essentially, our stage one is what we're undergoing right now, which is our full thrust congressional lobbying effort with respect to grandfathering. The next stage of that, and once we're hoping whether we get reauthorization just naturally, organically, or whether it's done through grandfathering or whatever the case may be, we really need to shift our focus towards the administrative side of things. So Congress can make laws, but it's the executive branch that implements those laws through regulations and through their agencies. Now, we of course know that there's a huge backlog at the USCIS. There's lots of concerns about processing times. So we do hope to use our lobbying effort as a continuation, and using congressional oversight offices and congressional liaison offices, be able to effect change on the administrative side of things. So our stage two would focus on that. And I would say that's fairly realistic, and also what we know, the stakeholders would desire. Now, stage three and stage four is really, I'll say that's more in draft state. These are our proposals we put forward. And again, we don't want to work in isolation. We want to work with the entire ecosystem of, especially regional centers, the two regional center organizations and other stakeholders to mutually develop this roadmap, stage three and stage four and onwards. So maybe I'll just kind of pause there and let people digest that. And of course, we'll take more questions towards the end.
We'd really like to know from our audience, and we're going to do this with our donors specifically, is what would you like to see us focus on? We know that certain investor communities want some things that are very specific, and we will have those discussions with them. But we also want to be clear that we want to approach legislative items or administrative items which we think are attainable. When we drafted FIFPA, we were asked by communities to add certain things onto it, and we didn't. We chose not to do that simply because we wanted a bill that was as easy to pass as possible to ensure that investors are being protected. So similarly, when we go forward with our future goals, when we advocate for things, we want to make sure we're advocating for attainable, common sense legislative or administrative items. The one question which we've been asked is with regards to litigation as an option if reauthorization does not happen on September 30th.
So the thing is that there's a clear demarcation between what the judiciary can do and what the executive can do, the separation of powers. Immigration and green cards lie strictly under the purview of Congress, the legislative branch. The judicial branch cannot just manufacture green cards or visa numbers out of thin air. There have been some cases going on, especially with the diversity visas right now, where the judge has ordered USCIS to reserve visa numbers for diversity visa applicants, but that's a totally different case with a different section of the law and different circumstances. It will not be possible to get you an EB-5 regional center green card if the program has been lapsed, and a judge cannot change that.
Do you plan to advocate for the ability to adjust status before I-526 approval? EB-5 is the only EB visa that does not allow for that, is what I'm guessing the question is.
I can answer that question. Mm-hmm. So I think you're talking about concurrent filing. So what concurrent filing is that when you file your immigrant petition, so in the EB-5 case, that's the I-526, concurrently or with that, you can also file an I-485, an application to adjust status. Now, EB-1, EB-2, EB-3, they all have that provision. So when you file your I-140, the immigrant petition, if a visa number is current at that time, you can also file an I-485 adjustment of status with that. EB-5 does not allow that. And if you actually look at our roadmap, the new roadmap, if you look at stage 2, we're actually going to be advocating for that, concurrent filing and e-filing. That's an administrative fix. That's not a legislative fix. We will focus on that, and that's something we will advocate for after we have FIFPA and reauthorization, definitely.
The next question is, would it not make more sense to determine what will be in the bills the industry groups will be supporting before deciding to lobby the FIFPA bill separately, or to lobby and support the industry bill instead if it includes it? Great question, Andrew. So the thing is, the groups, the two industry factions, have not yet put out their versions of the bill. They have talked about what it's likely going to be based upon. If the AB5 industry wants our support on their bill, they can start by showing us a draft of their legislation. It's really not that hard.
I will also add certain industry bodies, they want a laundry list of items, right? They want EADs and APs, more visa numbers, all that stuff. While we support most of that stuff, right? We would be really happy if existing investors can get EADs and APs before their adjustment of status period. It's going to be a tough sell in Congress, a hard sell. And attaching grandfathering to that reform bill, to a bill that might not even pass, that's why we need an independent effort for grandfathering. So regardless of what happens with the industry and their own dream package of reform, we at least have grandfathering secured. So existing investors are secured. And then we can have conversations about all the other items that the industry wants. Someone asked a question that, does the infrastructure bill currently in the House have EB5 reauthorization in it? No, it does not. At this point, it does not.
There's a question from Ash Gandhi about, we have received our I-526 and now waiting for constant interview date. Would our petition be covered as part of the FIFPA bill? So to answer this question, as well as the next one, which is, will the window be open when the regional center program is back? Will petitions applied before June 30th of this year, USCIS will honor it? So FIFPA does cover both. As far as we know, with regards to the second question, which is, will USCIS honor petitions that came in at $500,000 before June 30th? As per the immigration attorneys we have spoken to, they have said yes for now. I would recommend staying in touch with your immigration counsel to clarify that. But to answer the first question, what will FIFPA cover? FIFPA covers every single person who has applied for an immigrant petition under the EB5 visa program. That means someone, if you have your I-526 receipt in hand, if FIFPA were to pass, whether it's standalone or with an attached another bill, or the language being part of a larger reform package, in any of those scenarios, you would be protected. Your application would be processed. Even if there's future lapses in the program years from now, your petition would still be processed regardless of all of that. So that is why FIFPA has been drafted. We do encourage you to go through the blog post and actually read it, understand exactly what it entails. And yeah, we need your support for getting this forward. Everyone, I would encourage you as investors to reach out to your attorneys, your service providers, everyone, and ask them to support us. This is an important goal. If I would imagine anyone who has investors in the process, they care about them and want to ensure that their immigration petitions are processed in a timely fashion. It's not good when you have folks who are in the middle of adjustment or stuck in their home countries, who had visa interviews only to have been canceled. Those are really unfortunate scenarios, and we want to prevent something like this from happening.
So we got a question saying, what specific legislative language and steps will the Alliance support to improve I-526 processing times? And what's the timeline goal for processing? So right now, our full focus is on FIFPA, like we talked about in our roadmap. However, from what we know, that industry bodies like AIIA USA, they are planning to advocate for adding legislative language into the INA and the EB5 legislation, mandating USCIS to process I-526s and other EB5 petitions in a timely manner, maybe 180 days. And we will publicly support that 100%. If that doesn't happen and a reauthorization happens, FIFPA happens, and the processing time goal doesn't happen, we're going to independently do our efforts to ensure that that's enshrined in legislative language. Or even if it's not enshrined in the law, we're going to do administrative outreach to USCIS through Congress. Congress has an oversight authority over the executive branch. So we're going to reach out to members of Congress who have oversight over DHS and USCIS to pressure the executive branch, USCIS, to be more efficient in their processing times.
Yeah, look, I would say everybody can do their part, right? Our focus is obviously on investors because we need to help ourselves first and foremost. and then, again, from a strategic perspective, from a logistical perspective, our efforts are ongoing right now to get the help of other ecosystem, participants, like the attorneys, like the everyone who participates in the EB5 ecosystem, to put us in touch with those investors who either may not, be up to date on the state of the program, or obviously, inform them about the presence of an organization like us. Look, we would like to partner with folks that are in the industry, because the best customer service that that you can provide to your existing clients is by putting them in touch with people like ourselves, whose sole mandate is to serve that community. So, like, again, my final closing thoughts here would be just to sort of appeal to the participants in the industry and also the investors. Come forward, put the final push, get us over the hump, and let's get grandfathering done.
I just want to say that existing investors need to start making a lot more noise than they are at this point. We have placed our faith in the industry for so long, and while we really appreciate what they're doing, they are working towards to get a reauthorization. Existing investors need to hold the industry members accountable. AIIA is a method to do that. Please support this organization by volunteering your time, by donating, by spreading awareness about us. Do not sit on the sidelines, because frankly, the level of complacency we have seen so far, it's disturbing. No one thought this lapse. I was reaching out to journalists in February in 2021, harping on about this lapse. But the industry promised us this lapse will not happen. It happened. Now the industry is promising us something will happen before September 30th. It might not happen. So instead of sitting on the sidelines, actively engage and participate, work with us, donate to us, volunteer with us, and spread the word about us. That's the way forward.